Hey everybody, John the Other here, obviously. And today I'm going to read you something. But before I do, I want to ask you a question. And while I'm reading this, you can, hopefully come up with an answer and put it in the comments below this video. The question is this. Who, in your opinion, is the most dangerous, established, powerful feminist that you know of? Who is the biggest and most dangerous? And whatever your answer is, put it in the low bar. And there's no wrong answers here. But I'm asking you that question at the beginning of this video because I'm going to ask you again at the end. So you can answer twice if you want. And now I'm going to read you something. This is Vancouver Sun. It's a city newspaper for Vancouver, BC, which is where I live. And this is the paper of today, Tuesday, December 1st, 2015. I'll show you the headline. Okay, headline says, Rape Relief wants say in Henry trial. Now, I'll read you the whole thing. The subheading is, Attorney General supports group's right to be heard in wrongful conviction case. On the eve of the close of Even Henry's trial for the compensation of his wrongful conviction, Rape Relief is threatening to throw the case into procedural chaos. In a move Chief Justice Christopher Hinkson called disappointing, BC's Justice Minister Suzanne Anton backed the Vancouver organization's right to be heard. Quote, I was hoping for some assistance from the Attorney General. Hinkson scowled at government lawyer Jonathan Penner. Vancouver Rape Relief and Women's Shelter wants to apply for the appointment of an amicus curiae, a friend of the court, to put Henry's factual innocence on trial. His lawyers were outraged that could result in more witnesses, in particular victims of the 1980s sex crimes of which Henry was acquitted. Renowned lawyer Joseph Avray had difficulty containing his anger, calling one of the country's oldest women's rights groups a mere busybody. He said it was trying to get involved in litigation that was none of its business while foisting the cost onto the public. Hearing the organization would be a, quote, complete waste of time, and appointing an amicus will not only delay the trial, but also be highly prejudicial to Henry, Avray noted. This is an unprecedented application, he fumed. I know of no case, no authority, no practice in which a stranger to the litigation would have standing to ask the court to appoint an amicus. Both parties remaining in this suit are fully represented, the lawyer said. No one is asking for help, and an amicus does not traditionally call witnesses or lead evidence. The veteran counsel was almost apoplectic. Calm down, Mr. Avray, the judge said. There has never been a case that I know of where the court has entertained an application for standing by a stranger to the litigation, Avray repeated. The BC Court of Appeal in 2010 said there was no evidence against Henry and acquitted him of 10 sexual offenses against 8 women. Henry had been declared a dangerous offender in 1983 and spent 27 years behind bars. The City of Vancouver, which was responsible for police and forensic analysis, and the federal government representing national officials responsible for reviewing his convictions have already settled with the 69-year-old. Only Victoria, which closed its case last week, continues to defend prosecutors. Though the evidentiary stage of the trial is over, Rape Relief wants it reopened. Avray ridiculed the suggestion the organization was there to defend the interests of victims in the 1980s attacks, when its lawyer said she didn't represent any of the women. For Rape Relief, Gwendolyn Allison said the 42-year-old organization wanted to raise the question of factual innocence. She acknowledged it was a, quote, unusual move, but a route to the witness box was needed for a handful of witnesses, including 2 women scheduled to testify who were dropped because the city withdrew claims Henry committed the attacks in its settlement 2 weeks ago. Hinkson looked askance, saying Henry's innocence was not a question. Quote, the issue has been abandoned. No one is asserting presently that Mr. Henry committed the acts. You want to parachute in and tell the court to address issues the parties have no wish to litigate. This is not a matter of public law. It is a dispute between now 2 parties. But Allison maintained Rape Relief had a right to intervene because the lawsuit was, quote, public interest litigation involving the award of charter damages. Government lawyer Penner added the Attorney General thought the group should have standing to more fully argue its case. Hinkson was not amused. Mr. Penner, presently, I don't need to decide Mr. Henry's innocence or guilt, the judge reiterated. The Court of Appeal has done that. The applicant wants to reopen all of that and ask me to find, in spite of what the Court of Appeal had to say, that he actually did all these things. That's a sea change in this litigation. That goes to the merits of their application, Penner replied. The Attorney General doesn't take a position with respect to the application. The judge responded, telling me you take no position doesn't assist me at all. Avery accused the Attorney General of being a little disingenuous. By inviting this court to hear rape relief apply for standing for an amicus seems to suggest the Attorney General may be trying to do through the back door what it was not allowed to do and is not claiming to do through the front door, which is to say, claim that Henry is guilty, and that suggests to me perhaps an inappropriate stance by the Attorney General. Now, the article continues, and I've put a link to it in the low bar as well as some other links. And I want to talk briefly about factual innocence. Factual innocence is a legal term, and it means a person petitions for a document of factual innocence, which is an assertion by the court that they have been found to be factually innocent after a fraudulent or a false accusation. The rape relief people, the feminists, the grievance mongers, want to remove factual innocence from the repertoire of legal machinery. They want to be able to convict people without factual innocence. In fact, they want to be able to overturn acquittals in defiance of factual innocence. You'll also be happy to know that this request for amicus curiae, friend of the court by the rape relief organization in this trial, has been thrown out. But that doesn't mean that this is over, because this is now the standard activism policy of establishment feminists. They're not changing the law the way you're supposed to change the law through legislation or public discussion. They're changing the law by influencing court cases and establishing case law, which is not a legitimate way to go about affecting political change. Now I'll ask you that question again, the one I started this video with. Who is the most dangerous feminist that you know of? It's a trick question. All the names of feminists that you know are clown feminists. You know, the Jessica Valenti's and the Amanda Marcotte's and the Eve Enslers, Anita Sarkeesians, and all of the young, obnoxious media feminists. Those are clowns. Those are not the dangerous feminists. The dangerous ones are those acting in the courts, lobbying governments, writing policy white papers. And until the fight against feminism begins to recognize who the actual dangerous ones are, we're not even close to being in a proper fight, never mind winning. Thanks very much for watching, and have a lovely day. Okay, one last thing, completely different topic. On Saturday, the 5th of December at 8 o'clock, I will be at the Manchester Public Eatery at 1941 West Broadway watching my friend James do comedy and drinking beer probably. So if you want to come out, enjoy a comedy show, drink a beer with me, Saturday, Manchester Public Eatery, 8 o'clock and later, 1941 West Broadway. I hope to see you there. Thanks a lot and have a lovely day.